It has sent shockwaves through the country's legal and financial systems after Justice Nyakundi firmly declared that poverty cannot and should not be criminalized. In a bold decision that could redefine how debt-related cases are handled, the judge warned against the misuse of civil jail, stating that imprisonment should never be used as a shortcut to force debt repayment. The ruling now raises critical questions about the fate of Kenyans currently behind bars over unpaid debts and signals a possible shift towards more humane and lawful debt recovery mechanisms. Our crime reporter Mudhoni Brenda unpacks the implications of this far-reaching judgment. Take a look.
It is too obvious to need elaboration that to cast a person in prison because of poverty and inability to meet contractual obligations is appalling. To be poor in this land of Daridra Narayana is no crime. Recovering debts by putting someone in prison flagrantly violates Article 21 of the Kenyan Constitution unless there is proof of willful failure to pay despite sufficient means. These were the exact words of Justice Reuben Nyakundi, who sought to draw a line between civil jail and debt collection measures. In his ruling, the justice ordered the release of Barnabas Ngeno, who had been committed to Eldoret GK civil jail for failing to repay a debt exceeding 700,000 Kenyan shillings. Ngeno had been accused of trespassing on 5 acres belonging to his neighbor, cutting trees and using them for fencing. The plaintiff sought approximately 600,000 Kenyan shillings in compensation and interest. Justice Nyakundi critically examined the earlier small claims court ruling, highlighting several flaws. Notably, he condemned the practice of lenders using civil jail as a shortcut to recover debts. Lawyer Emma Kibiru agrees that civil jail should only be used as a last resort in debt collection, stressing that imprisoning someone for inability to pay is unacceptable unless all other options have been exhausted.
It is not the first remedy that should be given by courts, but it should happen as a last resort, and this should happen in the event that the debtor has been proven to have means, to be a person of means, and to be proven that they have refused to honor the debts through crude means.
But what does this ruling mean for debtors countrywide?
It is a relief for Kenyans who have found themselves in debts, and especially for those who have no means to settle the debts, for the reason that the courts or judicial officers have been given an extra task that prior to making a committal to civil jail, they ought to establish that the person, the debtor, has the means to pay, and or whether they are refusing to settle the debt.
Lawyer Emma Kibiru, however, assures that Justice Nyakundi's ruling does not spell disaster for lenders.
There are Kenyans who have debts, they have the means to pay, but they, through various means, fail to honor the debts. For instance, there are some who hide their assets. There are some who give misleading information regarding their assets, and so they escape. And remember, in these matters, even the claimants, the creditors, also deserve justice.
She further says that the ruling does not mean the default rate will be high because you can still land in jail for debt.
The ruling did not give an absolute right to debtors to be set free by courts. It only gave a ruling on how application of committal to civil jail was made.
Whether Justice Nyakundi's ruling tips the scales in favor of fairness is yet to be seen. But for debtors countrywide, one thing is clear: being poor is not a crime. Mudhoni Brenda for